Okay, so today we're looking at Supreme Court comparison question. Next week when we test, you're actually going to have to do one of these on one of the Supreme Court cases that we've done so far. That means you need to know U.S. v. Lopez, McCulloch v. Maryland, this one, Baker v. Carr that I'm using as an example, or Shaw versus Reno, which is also another case that we've done in this unit. So you got 4 different cases. You need to make sure you know the clause, the facts, and the ruling of each case. And you need to know those cold. Like you need to know those so well that like you're able to read and compare and contrast in your mind and then write about them, because you don't get to have a piece of paper when you do it. All right. So that's really critical. And on the Supreme Court, on the AP test, that's a really important skill. Eventually we'll have 15 Supreme Court cases, but right now we just have these 4. So this is a good way to start to kind of learn the process. All right, now, when you look at a Supreme Court case comparison, the first thing you should notice, if you look at the screen, is that you have 2 paragraphs, and they usually have details about a Supreme Court case that you've never heard of. That's okay. They're supposed to give you one you've never heard of. What you're going to have to do is compare that case to one you have heard of and that you're supposed to know by heart. All right, so that's important. Now, one thing that can help you out when you're reading is to look at Part A of the questions, so that way you know what Supreme Court case are you comparing it to. So let's go ahead and do that right now. A, identify the constitutional clause that is common in Colgrove versus Illinois and Baker v. Carr. So Baker v. Carr, oh, okay, I know what the constitutional clause is. You should be able to answer that question right now, or you could theoretically answer it. By the way, in a little bit, you'll need a piece of paper in order to actually answer those questions, and I'll give you feedback. So make sure you're ready with that. All right, then also notice that Part B is always the same in every single Supreme Court essay. Let's read it, and I'll tell you there's one little difference, but almost all of them are structured exactly the same. And it's a 2-point question here, Part B. Based on the constitutional clause identified in A, explain why the facts in Baker versus Carr led to a different holding than the holding in Colgrove versus Illinois. Couple things. Holding just means ruling. Holding, ruling. What did they hold? What did they say? So that's the first thing. But notice that you got to do a couple things here. One, you got to use the clause you identified in A. So always in some way mention that clause in Part B. 2, you have to explain the facts of Baker versus Carr. It's going to be explaining the facts of the case you know. Always explain the facts of the case you know. All right? Not every single fact has to be done, by the way, but the most important facts. And then this case, it says, why did it lead to a different holding than in the holding in Colgrove? So you're comparing and contrasting. So one, you state the facts of the case you know, then you're comparing it to the facts that you just read about. So in this case, Colgrove versus Illinois. So you got to say why it's different. It could be that it says why it's similar. So it could be similar or different, compare and contrast. You get 2 points for this. 1 point, describing the facts accurately of the case we know, and then 1 point for saying accurately why it was either different or similar in the Supreme Court ruling. So that's what you have to do every single time. That'd be 3 out of 4 questions, 3 out of 4 points, I should say, right there. And then the last one, Part C, is always an application question. It could be several different things, but I'll deal with that later on in this video. All right, so right now, let's take a moment and read the situation. We know they're comparing it to Baker versus Carr. If you don't remember Baker versus Carr, pause the video right now and study Baker v. Carr, the clause, the facts, and the ruling or holding, and study those right now. Take like 3 or 4 minutes and know them and turn it over and say them in your head. Because if you don't know them, then you're done on a Supreme Court question. If you don't know the facts of the case they give you, then you are not going to do well. Okay, you need to be able to do well on it. So let's pause if you need to. Otherwise, I'm moving on. All right, let's read. Colgrove versus Kenneth W. Colgrove, a citizen of Illinois and a Northwestern University political scientist, brought suit against Illinois officials to prohibit them from holding an upcoming election. Colgrove argued that the congressional districts lacked compactness of territory and approximate equality of population. The first thing you should notice is that this sounds similar to Baker versus Carr, especially in the last part there where it says approximate equality of population. So the districts don't have that. So take note always. Be thinking about the case that you know you're comparing it to, and you think, all right, so right now we're dealing with equality of population. All right, got it. Go to the second part. In the ensuing case, Colgrove versus Illinois, 1946, the court held that the Illinois districts were constitutional because existing law imposed no requirements as to the compactness, contiguity, and equality in populations of districts. So now, again, stop and think to yourself, how is that similar or different from Baker? How is that different than Baker? Because it says you have to say why it's different. So think about that. Okay? In the plurality opinion, Justice Frankfurter declined to involve the court in the redistricting process, arguing that the political nature of apportionment precluded judicial intervention and declared that, quote, courts ought not to enter this political thicket. Again, how is that different than the ruling in Baker? You're going to need to know that for Part B. All right, now we're going to practice writing, and I'm going to give you feedback on what I wrote. Now, sometimes in an argumentative essay, you could write different things and it would still be right. However, in a Supreme Court comparison a question, most of the answers are going to sound almost exactly the same. So what I'm going to give you as my answer, yours should be pretty close to that. All right, grab your paper and pencil, pause it if you need to. Otherwise, we're going to go on and start writing. All right. You're going to go ahead and write your answer to Part A. Identify the constitutional clause that is common to Colgrove versus Illinois and Baker versus Carr. You should be using your strategy of rewording the prompt and then including the constitutional clause. So you want to mention the cases in this. By the way, it is appropriate to just say the first name of a case. So Colgrove, Baker, you can just use the first name. But go ahead right now, pause the video, and then write your answer. It should be one sentence. That's all it is. Okay, I'm assuming you just wrote your answer. If you didn't, better pause. And now here, let me give you my answer to this, and yours should be very similar. The clause that is common to Colgrove and Baker is the Equal Protection Clause. Sorry, equal gets cut off there. The clause that is common to both Colgrove and Baker is the Equal Protection Clause. If you got that, you got 1 point. All right, second part. All right, you are now going to write an answer for B. Remember, B is 2 points. Based on the constitutional clause identified in Part A, that means you should mention the constitutional clause somewhere in your essay. Explain why the facts in Baker versus Carr, so that means explain the facts of Baker versus Carr, led to a different holding than in the holding in Colgrove, which means you should be talking about the facts in ruling in Colgrove to describe that difference. All right, so you're talking about the facts in Baker, the facts in Colgrove, and why the ruling is different. And make sure you mention that constitutional clause. Go ahead and write that. Pause right now. Okay, I'm assuming you're unpausing because you already wrote probably 3 to 5 sentences in order to write the answer for Part B. Remember, both parts. Part B is a 2-point essay. You get 1 point for describing the facts accurately for Baker, and then also a point for describing why the ruling was different in this case. Could be similar in another case. All right, here we go. All right, here's my answer. Your answer should be similar. In Baker versus Carr, Tennessee had a law that mandated redistricting every 10 years, but Tennessee ignored this law for 60 years. You might have written that a little different, but you should have the same gist. Some districts were widely different in population and thus a violation of this law. The Supreme Court ruled that this was thus a violation of the Equal Protection Clause. So that's my description of Baker. You should have a similar description, although maybe the wording's a little different. Now I got the second point. So that's 1 point. Now the second point. However, in Colgrove, the court had a different holding because in Illinois, there were no laws that impose requirements to have districts equal in population. So therefore, you get the second point because you're describing why it's different. I might have had a little thing on the end there and said, thus, it's not a violation of the Equal Protection Clause, but that isn't necessary, but you could have that. Notice, again, this is about 1, 2, 3, 4 sentences. Like I said, 3 to 5 sentences usually gets the job done here in B. If you wrote something and you're really not sure if you got the points or not, you're welcome to dump it in an email and send it to me, and I'll give you some feedback. All right, now we deal with the last part, which is the fourth point, and sometimes the fourth point is definitely the hardest point in a Supreme Court comparison question. In this case, we have a very common Part C, which is describe an action a member of the public who disagrees with the holding in Colgrove versus Illinois could take to change the district in question. So think about why it was different and why the Supreme Court ruled against Colgrove. What could Colgrove do, or someone who was interested, in order to change the situation in Illinois? That's what you want to write about. So take a moment and try to write a sentence or two that answers that question, and I'll share with you some possibilities that I had. Okay, pause now. All right, I'm assuming that you wrote a sentence already. If you didn't write a sentence and you're just listening to me, you're not getting the full experience of this. You really need to pause and actually have listen to me after you've already written. Okay, here's my answer choices. Possible choices. A member of the public could write or write letters to their representative to create laws. To create laws, sorry, I should say create laws that would require population to be equal in all legislative districts. So you could talk to your representative and say, hey, I want a law. Remember, the problem was there wasn't a law. I want a law that does this. So lobby them, get them to change things. A second answer that's very similar, a member could vote for representatives who would create a law that would require population to be equal in all legislative districts. So maybe your representative doesn't agree with this, but you vote for one that does. So you could always vote for someone who wants to change this. And then lastly, again, very similar, a member of the public could join an interest group that's lobbying representatives who would make a law that requires population to be equal in districts. The bottom line is you're trying to change the facts that led to the Supreme Court ruling, so that way you get a decision that you like. All right, so that's the idea. And when you're answering that question, that's what you want to do. All right, great. If you have questions, of course, email me and we'll go from there. Otherwise, we're done. Thank you.